attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about U.S. investments in foreign businesses and foreign companies trading in the U.S. public markets. Throughout this LawCast series, I have referred to Exchange Act Rule 12g3-2b. Rule 12g3-2b permits foreign private issuers to have their equity securities traded on the U.S. over-the-counter market without registration under Section 12 of the Exchange Act, and therefore without being subject to the Exchange Act reporting requirements. The rule is automatic for issuers that meet its requirements. A foreign issuer that is otherwise subject to the Exchange Act reporting requirements cannot rely on this rule. The rule provides that a company is not required to be subject to the reporting requirements if, 1, the company currently maintains a listing of its securities on one or more exchanges in a foreign jurisdiction, which is the primary trading market for those securities, and 2, the company is published in English on its website or through another electronic information delivery system that is generally available to the public in its primary trading market, such as the OTC Markets Group website. That would suffice. And the information that needs to be published is as of the first day of its most recently completed fiscal year and has been made public or been required to be made public pursuant to the laws of its country of domicile, has been filed or has been required to be filed with the principal stock exchange in its primary trading market, and which has been made public by that exchange and has been distributed or has been required to be distributed to its security holders. A primary trading market means that at least 55% of the trading in the subject class of securities on a worldwide basis took place in, on, or through the facilities of a securities market or markets in a single foreign jurisdiction, but in no event in more than 2 foreign jurisdictions during the company's most recently completed fiscal year. In order to maintain the Rule 12g3-2b exemption, the company must continue to publish the required information on an ongoing basis and for each fiscal year. The information required to be published electronically is information that is material to an investment decision regarding the subject securities, such as information concerning results of operation or financial condition, changes in business, acquisitions or dispositions of assets, the issuance, redemption, or acquisition of securities, changes in management or control, the granting of options or the payment of other remuneration to directors or officers, and transactions with directors, officers, or principal security holders. At a minimum, a foreign private issuer must electronically publish English translations of the following documents: its annual report, including or accompanied by annual financial statements, interim reports that include financial statements, press releases, and all other communications and documents distributed directly to security holders of each class of securities to which the exemption relates. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.